Virginia has two cannabis systems operating at the same time, and most people do not realize how different they are, how they are enforced, or why misunderstanding them can put residents, property owners, and businesses at legal risk. In this video, we are going to clearly explain what these two systems are, how Virginia law separates them, and why that distinction matters right now. Here's the context and why this video exists. Over the past several years, Virginia has passed multiple cannabis-related laws. These laws were passed at different times, for different reasons, and under very different political environments. As a result, Virginia now operates under two distinct cannabis systems that often get confused with each other. This confusion is not accidental. The language used in public discussion, online videos, and even local news coverage frequently blends these systems together. That blending leads to misinformation, false assumptions about legality, and in some cases, enforcement actions that surprise people who thought they were compliant. This video exists to separate facts from assumptions and explain the legal structure clearly, without promoting or encouraging any activity. Section 1. What are Virginia's two cannabis systems? Virginia currently operates under two legally distinct cannabis frameworks. The first system is the Virginia Medical Cannabis Program, which is regulated by the Virginia Cannabis Control Authority. This system governs licensed medical cannabis dispensaries, registered patients, pharmaceutical processors, testing laboratories, and medical certifications. The second system is adult possession and limited home cultivation, which was legalized under a separate statute. This system does not create a retail marketplace and does not authorize sales. It only permits possession under specific limits and allows limited personal cultivation under strict conditions. These two systems are governed by different sections of Virginia law, enforced differently, and carry different legal consequences when misunderstood. Section 2. The Medical Cannabis System explained. Virginia's medical cannabis system is highly regulated. It requires state-issued licenses, compliance inspections, seed-to-sale tracking, laboratory testing, medical patient certification, dispensary zoning approval. This system operates similarly to a pharmaceutical distribution model rather than a consumer retail model. Every product must move through licensed entities, and every step is documented. Importantly, local governments play a significant role through zoning, land use approvals, and location restrictions. Cities like Norfolk and surrounding Hampton Roads jurisdictions can influence where medical dispensaries may legally operate. This system is not optional or informal. Participation without proper authorization is illegal. Section 3. Adult possession and home cultivation. Virginia's adult possession law allows individuals over a certain age to possess limited amounts of cannabis and grow a limited number of plants for personal use. However, this system does not allow sales, does not authorize gifting with compensation, does not permit unlicensed distribution, requires plants to be tagged and secured, prohibits public visibility. This framework exists independently of the medical system and does not replace it. Many people incorrectly assume this law created a recreational market. It did not. Section 4. Why these systems are legally separate. These systems were created by different legislative acts and are enforced under different statutory authority. Medical cannabis is regulated commerce. Adult possession is a decriminalization framework. Confusing these two leads to illegal sales assumptions, improper business models, zoning violations, lease violations, enforcement actions. Virginia law treats intent, structure, and compensation very differently depending on which system applies. Here's a scenario and how people get this wrong. Imagine a Norfolk resident who believes adult possession means they can host a private event where cannabis is exchanged for entry fees. From a legal standpoint, that activity likely crosses into unlicensed distribution, even if framed as private or donation-based. This is where misunderstanding the two systems becomes legally dangerous. Section 5. Who this affects most. This legal distinction affects renters and homeowners. property managers, small business owners, event organizers, local officials, community organizations. It especially impacts communities attempting to build cannabis-related advocacy, education, or policy spaces without fully understanding regulatory boundaries. Section 6. Why this matters right now. Virginia is still adjusting its enforcement posture. Local governments, prosecutors, and regulatory agencies are interpreting laws in real time. Court cases, zoning disputes, and enforcement actions are shaping how these systems function in practice. Misunderstanding the separation between medical regulation and adult possession can create long-term legal consequences. What to watch next? In future videos, we will examine how local zoning impacts cannabis-related activity, the role of the Virginia Cannabis Control Authority, why Virginia has not launched a retail adult use market, how enforcement discretion works at the local level. Question. After learning about Virginia's two cannabis systems, what part of the law surprised you the most, and why? Please put your answer in the comments. If you found this legal breakdown helpful, please like, comment, and subscribe for more Virginia-specific cannabis law analysis. This channel exists to inform, not promote, and to help communities understand the law as it actually exists.